4.7 Asempa FM Sony all talk all day. Ekosiisen jumedie ena wasugu so a wutie ne yen discussion segment ye de Bremono Franco Trading Enterprise eboyen TCL the Creative Life dependable herbal omo de adoma laki abana Global Lighting Center Limited omo nso eka yen ho ena ye hwe ede yen discussion segment abremene lawyer Same Jemfi ena Edin Komo National Communications Officer NDC spokesperson for the petitioner in the ongoing election petition case at the Supreme Court. And Vals Day eba na Franco Trading the Franco Vals Day promo no aba. Franco Trading Enterprise is the leading mobile phone accessories and electronic retail outlet in Ghana. And any or more year Valentine's Day promotion. Yes, shall say 8th February. That's Enra. Yeah, the Bequery 13th February 2021. Now items are here ton and we're in a discount room into your tetes to say who your iPhones, your Samsung, your Nokia, smart TVs ranging from 32 inches to 55 inches, your tabletop fridges, and all other mobile phone brands and accessories from all our shops nationwide at a very discounted price. Into download the Franco Trading app on Play Store and also on your website francotrading.com. Na order onyoma online and so order you be deliver amount kama na so in shops bia ubetimi akwa benefit from this Valentine's Day promo discount ya de ama and discount no way esoso ankasa ya tete so pa men Canada your number is 0246 422 338 Franco Trading was still phone papa fee TCL the Creative Life and so say omonso some amazing deals and freebies here charge with discount of up to 15% on all TCL products this Vals season. Now, amazing offer win is available from the 10th of February, that's Ochana, to the 14th of February, which is Sunday, in all TCL showrooms nationwide and online at store.tclghana.com. Store.tclghana.com. Please beware of cloned TCL pages. The amount for creative pages be or social media nobody bunko for fast on me patcho and yet TCL pages and no. And we also don't accept Vodafone cash. We offer payment upon delivery within Accra and Tema. Get free vouchers to shop for a loved one anytime you buy from TCL this season. Call us on 0202 698 398 0202 698 398 TCL the Creative Life. Ekosiisen on Asempa FM. Same enti basically said you can't edibase yen nyina ye twen nyame ya no Thursday and what the court will say. But at this point baby my mu case akwa do as and more closely mu case. Meaning say, and I think one of the lawyers pointed that out, say in Puebasa mo ye application to subpoena EC chairperson na more closely mo case that into most subpoena is all made then.
Obi. Say Sanyama we dear and ya dear one was
okay.
You can always apply to the court for leave.
Even after closing your case?
Oh, yeah, to reopen your case and do something.
So it's possible?
Yeah, at the discretion of the court.
Okay.
At the discretion, but normal processes that a party can rely or can fall on. Even when you have closed your case, back to ask the permission of the court, that is leave of the court, say, respectfully, your lordships. Mama Yakwana Yensanso and reopen your case to do a particular thing. And if there are reasonable grounds for that, their lordships will agree. Until you drew why you cross. But I don't even want to say they drew her because right now we don't know what the outcome of this. For their lordships who have given an adjournment.
Yeah,
some were expecting that this is something that they will determine because within a certain time. As provided by CR 1990. Normally, some of these lengthy interlocutory issues that are debated, no more koba ebema ruling, but we don't know this. So I'm sure that they will take all the arguments now into consideration. Then the decision will come. We are hopeful of a favorable decision. So I don't even want to now talk about
subpoena no.
When we get there, we will cross it. And lawyer Chachuchi Kataka said he doesn't normally like to cross bridges when he has not gotten there. So when we get there, at least now I'm who say it is an option that we can explore.
So,
but I don't want us to make it look like that will become the eventuality because we don't know what their lordships will say. Your lordships can come and say that we also agree with the petitioner. Or maybe for other reasons other than what the petitioner has advanced, we think that the EC chairperson should go into the witness box. But they can also come and say that we agree with the respondents. So when we get there, then we can analyze the decision of the court. If we agree with it, we'll make it known. If we don't agree with it and we want to do something about that, we will do. And then see what other options are available to us.
So, Ebase, on the strength of more case amaye so far, no. So, court needs and also inquire judgment. Mubenya favorable ruling.
We are hopeful. In my view, on the day, what my dream would be.
Yes.
What the point I think that our case has been established. What my dream. But I'm not the court, and the law is in the bosom of the judge. So they will determine it at the end of the case. Because if for us, issue 2 is clear, the information or the figures contained in the declaration of 9th December,
the data contained,
whether the second respondent crossed more than 50% of total valid votes in line with Article 63. I'm just paraphrasing. It is so clear that the EC admits that the declaration was wrong. And it is so clear that if you take the data in that declaration and you work it out, the second respondent does not cross. Cross more than 50% of total valid votes. I've done it over and over again. We've done it, and it is in our petition. And anybody can do it.
But when Akutuan Powder calculator, all the different
declaration, calculation, because they do declaration. Also, I think he wanted to show, say, no matter the figure you will look at, your total value votes, man, penyo kufuado cross more than 50%. But one yes, analysis, to the 9th December declaration. You do 9th December declaration, he says, he won't use the 13,434,574, and he used another figure.
Because but that was a figure in error.
No, but that figure was not in the declaration. That declaration, the declaration specifically mentioned the total valid votes. So in our view, or in my view, I think that what the woman said is a total valid vote. If you are going to
calculation, be no was what they.
No say total valid vote. Now the team they go kweye. Na obedient na wo de be. The ono Bible so wanu mu asem na di bebu afo. Ono ana asem o de na no aka na yemfa no nto nche na yemfa hwan anu mu asem na nkoka.
How about omo e ka say same? We have the declaration. Which flows from an election. The declaration is a standalone event. You declare. And you can look at the declaration and you can also look at the fact of the election because among over 38,000 polling stations. The fact of that election, and if there was an issue with the declaration, does it change the fact of the election? Which fact is recorded on pink sheet in over 38,000 polling stations?
But when it is recorded, it doesn't end at that stage.
Yes.
It must be collated. So if the voting and the recording and everything is even accurate, but there are problems with the collation, then you can raise a challenge.
Yes.
Even if the collation is also done perfectly.
That's a problem with declaration.
But problem with declaration anymore. Because it is all part of the electoral process. In my view, that can also be a ground for a challenge. So, because of the fact of the election, what is before the court is about the election.
No, the fact of the election may say in the end, say problem with declaration. I'm a what challenge it, and based on problem now on the declaration, you are calling on the courts to grant you some reliefs. Some of those reliefs, would mean so we have to go back to the fact of the election. And see, go back to the fact of the election. The court can order, say, independent auditor. Beke pink sheet over 38,000 in Abu Boom. Nemayen result a winner. That fact, what does it say? And on a pushing call for say, okay, in the Monsomo Cancer, 38,000 plus polling pink sheet boom, no. What did you get? That will be the fact of the election.
Show, say, okay, as a conversation when you have with I can say, yeah, there are some to court. It's a dream when the free say a relevant to that case, improving the case, and only the court.
Yes.
And the evidence, free say it will help us to prove our case. We have presented that to the court. The issue about polling station at the boom, you say it is not relevant to case at that court.
I know you've established that.
So that's it.
You've established that. Maybe the American say, based on pleadings, I'm the Aquato court name. Any more reliefs are more pay. Do you think the court bit me a granted sanium because a about one amount for joining queue at 2 or more to about in over 38,000 polling stations? Meme koko to about polling station. It is a whole catch me say. Yeah, two abani in area nipe also declare results a mistake. In Tibima Bana me koko to yen should not matter. Which court would grant you that?
No, but nobody. That I don't think so. Any of the reliefs now, Bibi Umua is seeking to invalidate ubi votes. And now bisa court and they say court on take decision ebe say ubi votes. I don't think so about. Rather, not her case now. On the 2012 petition, the petitioner asked the court to annul votes.
That's true.
I get him.
Yes.
And I know the ubeti me business question. But here the young one vote to crown the court should annul. We are just saying that the declaration on the basis of which are what enacted, and on the basis of which are what and which she has gazetted, that declaration is faulty. And that declaration is faulty because per the data and unconstitutional, not just faulty.
Yes.
And we are saying so because per the data in there, the second respondent, more than 50%.
Data in the declaration.
Yes. And
yet data from the polling stations.
But what the declaration is supposed to reflect the results from the polling stations. Yes.
So
when you say the data in the declaration, you are
for the court to grant relief, say based on the data in the declaration, into Obia and cross 50%. Once the court, in deciding on that relief, rather go back and say, okay, then let's look at the fact of the election. Vote now for 2 saying an etie. So let's recollate again and see who crossed 50%.
It is part of the inherent powers of the court to do that. See, this uncle, because the court, but me the parties in the court can make certain orders
and we
as part of the process of ascertaining a certain fact. Because in 2012 there is a precedent. KPMG to do an audit, and they came in as
and remember, comment next question
at the behest of the court. And that for me will be in order.
And we assure us a court yes say independent auditor be audit all the pink sheet non kamum. Number candidate
the true outcome will be known. Because you see, because
which
you see, hold on. You see, I don't me as someone in court.
Okay.
Because they all kind of hypothetical case.
No, but say the consequential orders are court beat me, which includes this.
But you are speculating. On what basis? So far, I have not heard anything in the proceedings from beginning to end. That gives me reason to believe, say, maybe the court will order for a coalition. It is possible, but we cannot at this stage say for sure. Says Anna Court on the bay. And the amendment can say, let's look at the case of the petitioner, and let's look at the testimony of the 3 witnesses so far and how the cross-examination has gone. Even if what the respondents are seeking to do is upheld by the court, I still believe there was a compelling case before the court.
Court need just the granting more reliefs.
I'm not the court, but I'm speaking as somebody I believe in the case of the petitioner, and I'm saying that in my opinion there is a compelling case because you see testimony now, and even admissions from the respondents now, like I explained to you about, in particular, the data in the declaration,
yes,
and the fact that there seem to be some agreement among the parties. Yes, that declaration is faulty. And yet it is that declaration which was enacted and gazetted. And since then, we've not heard any new thing or any adibia yayene separate.
Second and third witnesses, are very much on their course to a strong room. And whether they were instructed to leave or asked to leave and what really was the point? If they were instructed to leave, let's even assume without admitting that they were instructed to leave. And so, impact here, then effect here, then because really 5, whether the alleged vote pardon and are the errors complained about by the petitioner, whether they materially affected or affect the result so declared on 9th December. And these are errors, yes, or Pamo, yes, free or yes, any way, no. How do they affect the result so declared? What's my question?
You see, what your petition,
yes,
your sons will raise issues about the conduct of Jimensa, not just the conduct, but the discharge of responsibilities.
Yeah, Article 296 there, no.
It you can say as a returning officer, no, or to me, so or yen might be brave about what an answer is. But or yeah, Jumana. There is a duty on her to be fair and candid and not to act capriciously and arbitrary. And say, what kwanya or fast we collation in Bobo Abano. One yeno in accordance with article, article 296 and article 23.
Okay.
Because in such a year or yen one involve political parties, one yeno with any transparency. Figures are whatever na assistant na channel for abaninano. Or my any explanation be a justify the changing figures. And see, that is why in our petition, the petitioner made a point to say we're breaching the constitutional duties and made reference to Article 23 and 296. Yasan's work about bad faith asem. So Yasan's work about due process. One follow. It is our evidence I would say about the course of national strong room was evidence from the petitioner in support of Sarkis na a year before the court. The issues of the lack of due process, the issue of bad faith,
and which due process say Ankosua would invalidate the whole declaration.
No, Ankosua. The courts, I believe, can take that into account in deciding or resolving the issues or setting it out.
Yeah, because the man
because for the petitioner, those other details are material.
Okay, because some witnesses too spending so much time, on their course or strong room. And I wanted to know, happenings, how would they? Because it comes down to the numbers. I also 5 issues now. Remember down to the numbers. How do they address issues 5 now? Court and set it down. Because even they are closely related to which is issue number 5. And no crackers. How do the alleged vote pardon and the errors complained about by the petitioner? How do they affect
the
declaration? Issue 5.
But there are other issues.
Errors now I'm complaining about.
No, there are. I'm saying there are 5 issues.
Okay.
So don't just center on
one
issue. There are so many other issues. You are not necessarily supposed to win all the issues before your release can be granted. So even if, in your view, we have not sufficiently, as a mekabro fododo, same other issues now court and they say obijina so edidi asem say assuming without admission say all kind of crazy the okay and crazy issue 5 and the intimate, so it doesn't in any way affect a dance here and in some way they are to court name about the other issues. And one issue crano if on one issue the court finds that you have a case that can lead to certain reliefs of yours being upheld and certain consequential orders being made in favor of you. So at the end of the day, it's not about winning all issues. With regards to pardon, in the case of the petitioner, I think lawyer Chachuchikata and your witnesses now making it clear. Say, we spoke. I think the witnesses, not lawyer Chachuchikata, but the witnesses have made it clear. Say, we just decided to present samples of those cases.
Not me, never bad been.
No, we for us in proving our case, what we needed were samples, and for us that is enough.
Sir.
Yes.
Samples are total number free mobano. A year infinitesimal enya share to the gap so declared.
Because that is your opinion. But the court at the end of the day, because the respondents have made that argument in court, but the court at the end of the day will take a decision on that, because in an election, you said there was only 50% plus one, or even like more than 50%. Then it means even one is important.
Yes.
Then apart from the fact that even one is important, when we are unable to ascertain now who the figures now, you are not able to know which one is the total valid votes, then you cannot say a figure be insignificant, because they are insignificant relative to what figure. You don't know. Maybe it is at the end of this case that hopefully we may know what the total valid votes figure is.
We say, Obi, 3 quick questions. Ask Sami Jemfi for me. Which irreparable damage will the petitioner's case suffer should the court uphold argument of the first and second respondent counsel not to allow their witnesses to mount the witness box? I know if it's a way you know that.
I've said that there are options. Other options that we can explore. Yes.
Why is the petitioner John Mahama no longer going to court? Throughout this trial, he's been seen in court on only 3 occasions. Or answer for you know.
Omambenyagu for the election petition go court, no. But you call courts how many times?
One day call be
I don't think so.
You sure?
I don't remember, but the only time I think I saw him in court, Omambenyagu for I think I saw him in court the day of the ruling.
Oh, you sure about that?
Yeah. So contrary evidence that you can share, because maybe I was not seeing him in court. I can be wrong. This is not something I'm saying.
Okay.
I can be wrong, but what I can recall is that day of the ruling that no court. But is there any law that says that if you're a petitioner should be you must always be in court? Okay. If he's not in court, or representatives, sometimes general, mosquito, or chairman and all that.
A single sitting.
Really?
Yeah, that's what Mami Efiakoto is saying.
Maybe she may be right. I don't know about that. But the point I'm making is John Mahama so messy, because to the extent say new court will be represented on. And that is the standard
representation. He was there in person.
But you are taking her word for it. I think I will have to verify if it is true that every day he was in court, because I don't think so.
Yeah. And also the ambassador never missed a single day in court.
Well, we will have to check and see. But I'm not very sure about that. I will double check and see if it is true. That's it. But the point I'm making is no petitioner or plaintiff in the matter is under compulsion to be in court. So no testify there. So the point that then no one was all but so no afraid witnesses, not witnesses dance manner. Then enough for the witnesses to go to court and testify for him. And no one can as on your bony D as a party was only representatives. And any day, every day I go court to be John Mahama has been ably represented by either the General Secretary, the National Chairman, or Vice
Finally, does Sami have the NDC's collated figures that the first witness for the petitioner, Mr. Asirin Ketia, claimed he did not bring to court on the day he was questioned by the bench during cross-examination? And that's the third question. Sir Obama questions or there. Sami, would you want to respond to that?
I've answered that. Me say it's relevant to what the case before now? The court. Okay. And I think our lawyer has said so in court.
Okay.
And I don't know why. I didn't know more person or more a case, my.
Now, someone's more person more easy case, man.
The young person your case be amount.
Most you on fire witness, or you on fire witness, man. Most you on fire witness,
no, based on one, no, maybe a wedding can ye say.
But say they are not bound by Sansam.
So we are entitled to oppose that they are bound. And at the end of the day, the court will decide. And when the court decide, then we can explore the options available to us. But I have even said that even if at the end of the day, Jim Mensah still doesn't come into the box, I don't think that it will affect our case.
It will affect my case. Okay. Well, so, Obi, please ask Sami, can the respondents question the petitioner on why he refused to bring all his witnesses Once I'm going to say 5, more than 3 now, back 2.
For me, and by court, I'm saying one of the eminent justices.
Mm-hmm. Okay.
And lawyer Chachuchi Kataka said to the extent that we have not filed 5 witness statements, but we have filed just 3, no, then that issue doesn't arise. The Jimensa one or no day na dance secretary day.
But you also said in your
that is why
petition,
we are arguing.
5.
Yes, but that one is in your pleading.
Was also signed by somebody.
Yes, that one is in your pleading. Then the court makes an order, say file a witness statements. Then you file 2.
Yes.
And then later on, with the leave of court, you add 1. So because I don't know 3 witness statements, but you are relying on 2, I will understand. But yet 2 witness statements, all the witnesses have been called into the box. We've applied to the court for their witness statements to be adopted as the evidence in chief. That has been done. And they have all been cross-examined. And the do baby, with the leave of the courts, another witness statement was filed. Witness in a swabber. That is different from Jimensa Dia. Or no, the witness statement about a true said the witness statement is not evidence because until she enters the box and swears the oath and it is admitted,
yes,
it is not evidence.
A hono so na se onya ko box nim swear oath at that point ontimi nsesa no say afi onye bio ontimi nsesa no yes
and in fact
call ho into obetima nsesa no say afi onye based on the strength of Mumu case amodi atuya.
We have said in fact that suggestion came strongly from the bench today.
Yes.
By lawyer Chachuchi Kataka said orders na easy for nigina so they carry your mokana. There is a certain precondition which talks about if they elect not to give evidence.
Yes.
And that in our view, they have elected to give evidence already. And then there was a question that can they change their mind? And our lawyer said they can change their mind, in our opinion.
Okay.
But they will have to do that with leave of court and give reasons why. That was the submission of our lawyer.
Of court and application.
Not application may not be.
It's a bit my viva vote.
But we are saying that so far they have not put that before the court.
So today, what did he do? What did
all I heard Justice Amanuvo say was that we don't intend to call any witnesses.
But that's
we have closed our
request before the court.
But I'm saying that no reasons have been given about, according to the arguments of lawyer Chachuchi Kata today in court, about that change of mind. And in fact, he went on to say, if there are suggestions that she cannot be compelled to come and give evidence that will incriminate herself and other human rights concerns,
yes,
then there was we cannot assume that for her because no cry your consent.
Oh, okay.
So Obi, media, I am very happy with how the petitioner are conducting the case in this matter.
Specifically, how will the presumption of regularity play out in this?
With regards to what?
With regards to Jean Mensah and how he conducted the election as a public
But the presumption of regularity is just a presumption. It can be rebutted.
Yes, it can be rebutted.
And I think that where the petitioner's case, any the evidence we have adduced, we are seeking to rebut that presumption. If I thought that presumption applies to this case.
So a court in a bit,
but
court in a granted.
Normally,
and the point is, are you sure, sir?
Normally, but
in
all cases now, which may apply certain principles.
I know.
But I'm trying to say, sir, even if it is applicable to this case, it is just a presumption, and a presumption can be rebutted.
Have you done that?
I've explained to you that in our view,
you have done that.
The witness statements, the evidence now you're putting before the court.
Okay.
I review all these issues, and for me, the cross-examination from the way it has gone, for both respondents, shows certain admissions about a case, a why case, So, if Jimensa comes into the bust, not only and just say be about the petitioner's case per se, in my humble opinion, yes, it is true that it will be in the interest of justice. It will bring clarity on a lot of issues. Right now, there is ambiguity because she's at the center of everything. Like today, Church Trikata said, she's at the heart of issues in controversy in this matter. So, reasons now. But I think that above all, Ghana for who say, a returning officer or an EC chairperson who can be trusted, who is credible, who is diligent, who is competent, because her competence, we will see it, her diligence, her truthfulness, it is under cross-examination and a council had the opportunity to test all those things. And I am saying that, and some people can figures or thrown around that. Yeah, some of us, even before we went to court, we said those things were not true. No, this would have been an opportunity, or not would have been. This will be, if granted, if the court says she should come into the box, now it will be an opportunity for us to test all those things and see who was right. Was Jean and the Electoral Commission right when they say they've done a correction and the figure is this and that is the correction, or they are wrong? Is it true, like we have said in our witness statements, that figures were cooked to achieve a predetermined outcome? All those issues, or say figure be a total vote cast, or the Form 13 be about all these issues, the questions surrounding it.
And not to help Momo case. Then the court will go like, okay, the moon here to help Momo case there. Let's look at more petition. And
it is not about helping your case. You see, Obi, everybody goes to court to win.
Yes.
So ultimately, we are looking for victory.
Which victory you can get without
the interest of the petitioner or the NDC, say you bring victory, no, and override the national interest, and for that matter, for me, the interest of justice. And even if justice is done in a case, now you even lose the case. There can be reforms as a result of it. There can be good lessons that enhance a democracy as a result of it. So we should not look at this issue as a win or lose for the petitioner or the respondents. We should look at the facts as they say, Mimi Yaganeni, Mimi Obi ni Yansamchuni. Don't you want to know the reason for the different figures? Are you not interested in that?
Would we know that only when she's in the witness box?
She did it. She's the returning officer.
In her answer to the petition.
No. If you have seen any such explanation, show me. And if you have seen any such explanations, I have not seen that. And I think Ghanaians at large who have monitored these proceedings, then we all should be interested. And found will say at the end of the day, the petitioner will win or not. But at the end of the day, the verdict never reflected your will as we expressed at the polls. I think that all of us, even including our friends in the MPP, should be interested in the returning officer coming to explain those issues.
This argument will suffice. Say, okay, there is a petition to the president. The president then set a public inquiry as a parliament and set a public inquiry. No more call into us. And the Ghana for because okay. Who the course so electoral commission chairperson or met before parliament no said who US no were you elected to go to court in court law procedure as part of the procedure no respondent need to make us say no as part of the procedure I don't want to put my witness in the box and your moral situation
no that is their case that is their case
and no doesn't work in
Obi, that is their opinion. Argument we have a counter opinion.
Yes.
And the court says we will rule on that on
and my counter opinion should be based on law. And your moral
are you suggesting Are you suggesting that lawyer Chachuchikata submission and he was talking about moral situation and not law?
I'm talking you.
But I am here as spokesperson for the petitioner.
It doesn't mean you are saying what Chachuchikata said.
But Chachuchikata's argument, no.
Interested. That
was what lawyer Chachuchikata meant. No, what is what lawyer Chachuchikata meant when she says, when he says, the nature of the responsibility of this witness we are talking about, or potential witness we are talking about, is of grave importance because she is the returning officer. All the figures we are talking about are in her bosom. The declaration she made and the basis upon which she made that declaration are in her bosom. So when that person is available, it will be in the interest of justice for that person to testify. It will even help the court in the resolution of in our opinion. Sort of point I'm trying. I don't necessarily have to use verbatim the words he used, but that is in substance what he's saying. He even made a point. He said this is not a civil litigation between two competing private interests.
Yeah, but it's still a
this is about
litigation.
No, but it is different. No, the court has held in cases. Say election petition, a different kettle of fish.
But it's still a civil
different character. It's civil case, but not all civil cases are the same. Not all civil cases are the same. And so we are saying, say, this is not also any other election petition. This petition, for me, per my understanding and reading of the petition and what has transpired so far, is centered on the conduct of the returning officer. Everything, whether it is the declaration, she did it. Whether it is the enactment, she signed it. Whether it is the Gazette notification, she did it. Whether it's the changing figures and all that, she is the only person who can speak to that because she's a returning officer.
About her,
yes.
But lawyer, and said you wouldn't even know as a lawyer yourself. Lawyer be court with a strategy. Lawyer be court with a strategy, and at this point, the respondent thinks the first respondent thinks per almost strategy, this is the way they should go. You don't determine their strategy for them. As long as that
but we can disagree with their strategy.
Absolutely.
And
as
then
long as the strategy is not against the law, you allow them to use their strategy.
But we have said that almost strategy, and tenable. And lawyer Chachuche Kata has addressed the issues of rules now more rely on and why they cannot rely on those rules. The case law that he cited, he has shown why some of those cases cannot be applied to this case. He has also cited other cases to explain why the Okane and Okre were referred to Jim Mensah affidavits before the court and what Jim Mensah Ankasa Kanye in those affidavits. Say, the application for leave to serve interrogatories on her, the court now granted no injury will be done the petitioner because we will have an opportunity to solicit for answers and argument in about more than an hour. So, and I believe it is for good reason in a court, to give this reason. We will wait for the decision of the court, and we are hopeful that a favorable decision will come. But even if it is not favorable, like our lawyer has served notice today, there are other options that we will explore. And Obi, in conclusion, Mamenka, maybe before I say that, let me say something. Obi, I draw my attention to something that I said Jim Mensah can go to jail. I was referring to coming into the witness box where you are going to swear an oath. And he said, what swear oath? Not during cross-examination, you be asked questions. Now, what can't someone then you can be prosecuted for perjury. So that's what I mean by that. I'm not just saying that So what I'm saying is that not just NDC supporters, but Ghanaians at large, Asedabema lawyer Chachuche Kata. Today, I mean, we need to honor him and celebrate him for how competently he has represented the petitioner in this case, and not just that, the submissions, the arguments. Oh yes.
When he's lost all the interlocutory,
it doesn't matter. It doesn't matter. Those are interlocutory applications anyway. They are interlocutory. But even when Obi Lusu, ball will be a Lusu match. By a but the point I'm making is that you can lose an interlocutory application in court, but people are also watching. Okay, and they may have a view different from that of the court. So, is it not strange that even though, like you are saying, it appears he's losing applications in court, yet the applause he's getting
from who
in the public space is on the ascendancy? It means that he's doing something right. I'm inspired by his advocacy,
but you are
by
not
his
in the
knowledge.
court of public opinion. You are in a court of
I'm
law.
not talking about court of. I mean, you see the word court of public
applause
opinion.
the free public opinion.
I said yes. That is also important.
But because that doesn't change what happens in the court of law.
It doesn't change, but it is also important. So I'm saying, even sometimes, because you see, Obi, there have been occasions court timima a certain decision be not in favor, but later on, wo dia na court na nyantu munokwan eno na ebe prevail eye adwuma. be in the course of time. And maybe why they can only be settled by time. So you are very conversant with real kutu. What they are there? Even though Geoffrey being more winning. But the real Joseph Dankwa Modiano and I celebrate, even though they lost in that matter. So sometimes too, you have to also look at the bigger picture and the long term. And not just me. I know that even Ghana for NDC for sometimes when you go on social media and you look at certain people who are commenting on this matter, you see that people are very impressed. The simplicity of his communication, the clarity of his communication. How sound, logically sound his arguments are, and he's grounded on law and all that.
Your lordships, not even one person.
That is also not accurate. There have been so many issues were convincing their lordships or my grant because that is very in fairness to the court. We need to say that because
apart from
the
where you were allowed to go and amend the petition,
apart from when we were allowed to amend. Even Rojo's evidence and when he came in and how he came in, was through the applications to the court. On the issue of the objections, Akutampa raised in connection with Rojo Metonunu's witness statement. Out of 23, the court dismissed 18 of those objections and upheld only 5. So Chachu arguments were upheld 18 times. That is no mean thing. And you don't create an impression that anything he has told the court has rejected it. It is not accurate.
So my fancy.
Yeah.
And I believe from this
interview, I thought our brothers from the MPP will come.
Yeah, unfortunately, we don't know. But Nipa there was about Henry Nanabuache. We are told when your emergency being to me.
We hope say Bibia Boko.
Yeah. I should think so. I should think so. Inti yebe jama wako na wako to our Juma so. Now party Juma no what that's so here. Because that's a court na your attention,
No say party Juma ni bia na court then party
Juma.
This is party work.
The party is not
but who is the petitioner?
The petitioner is John Mahama.
That's our flag bearer for the 2020 presidential election. That's why you see General and Chairman and everybody in court. So John Mahama is not in court just on his own behalf. Yes, the way the nature of the new CI 99, he must be the petitioner. But he's doing this for on behalf of the party, and not just the party, but the 30 million people of this country. And then lawyer Chachuchi Kata can be say, we are ensuring that public officers be who say yeah dwuma e your som na wo de som omanfo so hu na wadwuma na wo ye no so ye wo ho kwan say ye ma wo bu hu akonta kire because ye na wo som
your party be rated Nanado for taking a similar decision.
No be any will be rated Nanado for going to court. Never. Really? No, the issue about annul this and declare me winner, annul 4 million votes and declare me winner. No, you can't say
the party did not berate Nanado for going to court.
Never. Going to court and we even told them to go to court and they went to court. I don't think anybody berated President Akufo-Addo for going to court. Never.
In this Ghana,
never, nobody has done that.
Hey, Sammy.
So maybe point and they say Yantekisa step where will be emboldening certain people to engage in wrong conduct and things said there will not be any repercussions or they will not be held to accountability. And so every Ghanaian, it doesn't matter how this case goes, we should be interested in the case and follow the case. Now, ensure say at the end of the day, justice will be done and we be entrench democracy. Now, enhance democratic credentials. Now, the true will of the people as expressed on 7 December 2020 will be given effect to. And when you hear but that is supreme.
And what casache oh nyumbi abza me boma wana.
Say me di kan buy and I me say bonyoma me. And I would de ko nwan ya. Nyum tie. Nyuma me bisa no ye be no nyame hu by Dr. Keke Kabobo. Bisa ma oba hema Mrs. Jean Adukwe Mensa.
I don't know which one you man.
Oh, they be say me pese mo bonyo me man. Ontie na emu asem no mfa nya futu. Ti boma me Dr. Keke Kabobo nyum ne hu ya pa. Boma me ansa na me free.
Ekosiisen is the higher Empire FM.
Asempa FM.